Yes, please.
Item 1.
Yes,
Yes,
Mr. Tony.
well, DCP PS, my lord, it was, my lord, against the illegal search and seizure, my lord. Taken place way back in 2014, my lord. What happened, my lord, because the petitioner, my lord, alleged that, my lord, section 74 of the Assam Value-Added Tax Act since repealed, my lord. Under that provision, my lord, the department went for search. And my lord, seizure was subsequently taken place. Indeed, the whole process, what happened, my lord, because my lord, the mandatory requirement of the compliance of criminal procedure code provisions, my lord, that the lady police officer, magistrate presence, my lord, they were totally, my lord, it was not followed, and my lord, the charge was taken and seizure was made, my lord. So, my lord, in fact, like it was since the, my lord, the officers of the department. The highest officer of the department was also involved, my lord, in the whole process. So, my lord, appropriate forum was High Court, my lord, because the revision, the commissioner, additional commissioner, my lord. So, my lord, it filed before the High Court, the petition was filed, my lord. So, my lord, landed single judge, my lord, after, my lord, when the case was in the part 2 list, my lord, when the matter called, my lord, now both the sides were absent, my lord. So, my lord, the landed single judge, my lord, going by the pleadings, my lord, disposed of the case. And my lord, observe that the only thing is that it may come to the first, my lord, the order dated, my lord.
So this judgment was passed without hearing either side,
Yes, my lord.
is it?
Yes. But the whole judgment was based upon the affidavit and the pleadings of the.
No, but then what to do if the lawyers don't turn up? What does the judge do?
No, my lord, my lord, normally, my lord, I have no, my lord, nothing to say on that count, my lord. In fact, my lord, normally, my lord, when the it is the usual practice, my lord, both the sides are absent, my lord. The honorable court will definitely go by the pleadings and pass the order. My lord, while what happened, my lord, in this case, my lord, honorable court, my lord, while passing the order, my lord, if you lordship will see the order, my lord, in fact, look till the matter except, my lord, writing one what is set aside, my lord, because they after 1 year they again, my lord, sub demand notice. So, my lord, may I read the order, my lord? May I read the order, my lord? The operative part of the order, which your lords will find it.
Yes.
It is, my lord, it is order is at page 120 annex 1, my lord. And if you look to the operative part, but first, my lord, learned single justice refer to the, my lord, the provisions of section 74 of the Assam Value-Added Tax Act, and, my lord, the compliance of the CRPC provisions, my lord. May I read, my lord? The first lordship may come to page 122, my lord. None appeared in the petitioner, though none had appeared in the petitioner concerning nature and the issue involved in this writ petition, the grievance raised by the petitioner, and the relief prayed for. This court is of the view that the writ petitions can be disposed of on the basis of the pleadings made in the writ petitions. In this writ petition, the petitioner firm, namely Sri Krishna Enterprise Bilasipara Dhubri, had challenged the search conducted in the petitioner's farm and the seizure of certain documents and goods of the petitioner by the taxation authorities, apparently in exercise of the powers under section 74 subsection 3 and section 4 section 4 of the Assam Value-Added Tax Act 2003. The petitioner has alleged abuse of authority by the respondent authorities, containing that the aforesaid search and seizure was effected without following due process of law. Thereafter, my lord, the landed single judge has referred, my lord, the affidavit also, my lord. The affidavit may read, my lord. The respondents have filed affidavit in opposition containing that the search and seizure conducted premises of the petitioner was legal as per provision of some Value-Added Tax Act 2003. It is stated in para 7 of the affidavit in opposition that before entering the business premises as well as the residence, the tax officers identified themselves as tax officers and also shown authorization to search and as required under some Value-Added Tax Act 2003, duly issued by the Commission of Taxes Assam. It is stated that search was conducted as per provision section 74(4) of the seizure was made under section 73 and 5 of the Assam Railway Tax. It is also stated that absence of the petitioner, the search was conducted in presence of the petitioner's father and 2 other witnesses. As regard the allegations of the petitioner that the search was conducted by the officers without accompanied by police, including lady.
So
police
was there any arrest made?
No, my lord.
Only search and seizure.
Search and seizure, my lord. And my lord, in fact, my lord, department.
I think this judgment passed on 5/11/2019.
Yes, my lord.
On what grounds?
My lord, Lordship may kindly come to that after referring my lord similarly to provisions, my lordship may
That's
kindly
it.
come
What is the ground on which this order is being challenged?
No, ground means, my lord, in fact, like, my lord, so far the order, my lord, we are not, my lord, unhappy with the order. Order is, my lord, correctly made. Lordship may kindly see page 126, para 7. If I read, my lord. Only,
Yeah, we've read it.
so my
what is
lord,
the
in fact,
relief
my lord, Lordship has said, since search was made way back in 2014, my lord, and they ought to have complied with that the provisions of the CIPC provisions have to have complied with. So, my lord, thereafter, my lord, Lordship had observed that if anything survives, then the petitioner may come to before the approved forum. Since the approved forum is before the High Court, so my lord, in fact, nothing survived because the Honorable Court has looked into that. My lord, the provision of CRPC was not complied with. Section 74 was not complied with. So, my lord, they rightly concluded. But since the, my lord, the order was not set aside, only the, my lord, set aside while it was missing, my lord. Because of that, my lord, the department took my lord, under the impression that, my lord, still the, my lord, it was upheld. Their actions are upheld, my lord. That was the case. My lord, that is the.
So then, is it not a case where you should seek a review or clarification of the order? What can the division bench do here? We can't set aside this order.
No, set aside only, my lord, I am obliged, my lord. In fact, my lord, so far to clarification, only my lord, clarification to the regard, my lord. And thereafter also, my lord, what happened? After the passing of the order, after about 1 year, my lord, what they did, my lord, department started demand notice. There, my lord, under single judge again, my lord, clarified its order. Lordship may kindly come to page 137, because IA was filed, bringing on record, my lord, subsequent action, my lord. So, my lord, Lordship may kindly see that 25 January 2021 order, and page 139 is, Lordship may kindly come to page 139. May I read, my lord, para 5. The said petition was disposed of in absence of the counsel of the petitioner, as none appeared for the petitioner on that day. However, this court, referring to the affidavit in opposition filed by the respondent, did not go into correctness of the impugned search and seizure, but made an observation that provision of CRPC 1973 ought to have been scrupulously adhered to at the time of effecting any search and seizure while conducting the same under the Assam Railway Tax Act 2003. 6, my lord, this is important. Since the search and seizure of the documents were effected way back on 3/9/2014, this court did not make any finding, but as regards the validity of this said seizure challenged in the writ petition, but made an observation that if any cause of action still survives, the petitioner would be at liberty to approach the approved forum. Meaning thereby, my lord,
No, Dr. Toddy, you see, you are an immensely experienced counsel. The learned judge, when you ask for clarification, the learned judge says, if they are aggrieved by the notice, you are at liberty to file a proceeding.
correct.
But that cannot be done in an IA filed in a disposal petition.
Correct.
And so then you challenge the main order.
My lord, in fact, my lord,
What we'll do, we'll admit it and post it for hearing, that's all. But how is it going to help your client?
my lord, in
Are you not required to challenge? It's a fresh cause of action, new notice has been given.
case order is simply is a reiterate demand.
We'll admit and post it for hearing. How does it help you?
But only, my lord, I leave up to your.
Those notices will not be interfered with in this.
My-
I have
in
no
fact-
doubt about
In fact, my lord, impliedly, my lord, if my understanding, my lord, but since my lord, again, my lord, after the, there are also, my lord, the landed single judge has observed that, if anything survives, Yes, in effect, my lord, as per the the honorable court, my lord, nothing savage, because my lord, because what is but except
No,
the
no, in the second order, the learned judges say that the notices could be open to challenge, but that challenge cannot be entertained in an IA
correct, my lord.
filed in a read petition which is disposed of.
Correct, my lord, it was his
So
mistake.
then after that was done, now you are challenging the main order.
But in fact, my lord, challenging my lord, it's like
All right, you argue. We'll admit it and post it for hearing.
as you
But the
see.
demand notices cannot be interfered in this.
But only my lord at the time of hearing, my lord, after the lordship, my lord, court finds that my lord, yes, the my lord ought to have set aside in view of the order passed, my lord. Or that will solve the whole issue, my lord, to my
In the
understanding. my lord.
meantime, they will be at liberty to go ahead with the demand notices. That cannot be interfered. There is no challenge to that. There is no challenge to the demand notices.
But we'll take care of that, my lord. Also.
Huh?
We'll take away. We'll take my lord.
It cannot be done.
But in fact, my lord,
But
only
Dr. B.P. Tori, learned senior counsel assisted by Mr. A. Nath, learned counsel for the appellant. I also heard Mr. B. Chaudhary, learned SC Finance. This appeal is of SC Finance and Taxation appearing for the respondents. This appeal is directed against the judgment and order dated 5/11/2019 passed by the learned single judge in WPC number 6364 of the 2014, disposing of the writ petition. First of all, we have heard submission, we have considered the arguments made by learned counsel for both the sides and have also gone through the impugned judgment. First of admit the appeal. Since the parties are already represented, no formal notice is required to send in this case. Register to list this matter for hearing in usual court.
till then, my lord, they
It cannot be done. That's what we said. We are surprised why no action is being taken to protect the client's interest. How can a subsequent demand notice be stayed in a writ appeal preferred against the judgment of the learned single judge?
my lord, in fact, my lord,
And that too after the learned single judge has observed that you are at liberty to challenge the notices by filing appropriate proceedings.
my lord.
Question doesn't arise. We will not do it. It ought to have been filed.
No,
This judgment could be a ground to interfere. But instead of doing it, you have challenged the judgment itself, which has observations in your favor. And there you want the notice to be stayed. How is it possible?
My lord, limited, my lord, prayer before the lordship, my lord. But if my lord, lordship, my lord, that my lord, in fact, my lord, apart from the demand notice, my lord, the whole judgment, my lord, that only the clarification sort of thing, my lord, that whether, my lord, it is absolutely, my lord, was away, my lord. My lord, leaving apart the demand part of it, my lord.
Mhm.
So, my lord, suppose the, my lord, whatever the order part,
But first of all, you tell us why are you not challenging the demand notices?
but in fact, my lord, that was a
You not challenge the demand notices, and you want all kinds of this,
the
that.
demand
Why
notice,
should
my
we
lord,
do it?
only, my lord, my respect to submission before
Hmm.
lordship. Only, my lord, whatever it was there, my lord, they just asked for payment. Only that's what, only to that extent.
What else? In a demand notice, what else will they ask for? Demand notice is meant for asking for payment.
My lord, my lord.
Only that will be asked. What else can be asked in a demand notice?
But only, my lord, if the, my lord, if the clarification, my lord, that the earlier, my lord, which is with appeal, my lord, so far the appeal, my lord,
Mr. Todi, let the request be reasonable and within the parameters of law.
true, my lord, true, my lord.
You are aggrieved by demand notice, you are challenging something else. You want a stay order of something else which is not challenged. How can a division bench grant this kind of relief? That too in a revenue matter. These matters will have to be scrupulously examined.
My lord, true, my lord. No
That
doubt
is
about
not
it.
even under challenge.
No doubt about
The
it. my lord.
demand notice is not even under challenge. You are challenging an order of the learned single judge, which apparently is in your favor.
Yes, my lord.
And when you went for clarification, there also the learned judge has very rightly observed that in a IA filed in a disposal writ petition, demand notices cannot be interfered with. Therefore, liberty was granted to your client to file appropriate proceeding. And the appropriate proceeding now that has been filed is an appeal against the order of the learned single judge disposing of the
In
writ
fact, my
petition.
lord, so far the, my lord, this appeal is concerned, my lord, therefore, so far that, my lord, the land, my lord, our, my lord, the whole the grounds and, my lord, the appeal, my lord, that, my lord, it was specifically, my lord, it would be allowed or something. Or
That is
something.
your opinion. That is your opinion. Your opinion is this, the learned judge's opinion is something else. We'll see whether which of this is correct. That can be done in a hearing. But how does it, how are you going to store the notice?
My lord,
We are not dismissing the appeal.
my lord, but I have a responsibility, my lord. My lord, but I oblige, my lord, you wrote it. But only to leaving aside date, my lord. In fact, my lord, see that part, but so what appeal to the earlier order. That my lord, we have stated that, my lord. In fact, in absence of my lord, it was not, my lord, only the seeing of one word, but allow or my lord the seeing or my lord the interfered with my lord. Then my lord, the whole matter would have been solved, my lord. That's what my lord.
That's correct. This could have been done in a review petition. The review petition, this matter could have been sorted out. Either the learned judge would have clarified and set aside the order, or it would have been declined. But today, there is no clarity as what has happened. The observations are, you are right. The observations are that they are to follow the process of law scrupulously. But whether it has been followed in this case, there is no observation.
Yes, no.
The only
only one
observation
word
is that
missing of
it is
one
a
word.
matter of 2014, so no observation is required. To that extent, you may have a grievance. We will examine it. But on that ground, a subsequent demand notice
No,
cannot be
my
stayed.
subsequent demand is what that is, my lord, we have not even my lord, pleadings also, my lord, we have not brought into all those things, my lord. That subsequent demand notice, my lord, we have not, my lord, only stated, my lord, properly order passed on the earlier occasion, my lord, 2019. Only, my lord, that my lord, one word, my lord, that is the whole creation of the whole
So
project.
that cannot be done today.
Two,
We'll
my
have to
lord,
do it.
two, my lord, two, my lord. And I'm,
We'll do it. We'll do it. The court is not rejecting your submission. Only the prayer for interim relief, we find that it is not within the well-laid parameters of appellate proceeding. So you challenge it. If your client is advised, let him challenge,
Yes, my lord.
and that will be dealt with in accordance with law. All right, Dr. Shodhi.
Yes, obvious, my lord. The
Yes.
second case also, my lord, is a related case. The second case, my lord, that also at the time of hearing, my lord, were made. The second case is, my lord, is a different form altogether, my lord, but the combined order was passed.
Acha, this is also same order.
Same order.
Same, date is same, 5/11.
Yes, my lord. But the case is different altogether. There are no notice, nothing, because that search was made, but it's a different form altogether, my lord. But in the same campus, my
Acha,
lord.
you write Dr. So-and-so, assisted by so-and-so appearing to the appellant, so-and-so for the state. Appeal is directed against order dated 5/11/2019, passed by the learned single judge in WPC number 6364/2014. We have perused the interim order. Dr. Todi submits that this matter is connected with item 1, put the case number, which has already been admitted by the court. Full stop. Having heard the submissions of learned counsel for both the sides, we are inclined to admit this appeal. Full stop. Ordered accordingly, registered to list this matter along with item 1.
Much obliged.
Item 3.
My please, Lordship.
Yes,
I'm
please.
appearing as amicus. I'm appearing as amicus curiae for the first document.
Appeal has not been admitted yet.
No, Lordship.
It has come up for the first time.
All right, then we'll admit the appeal. It's
Lodge.
appeal against conviction.
Conviction.
All right, you take down, heard Mr. S. D. Professor and amicus curiae appearing for the appellant, also heard Ms. S. Jahan, and APP Asan appearing for the state. This appeal, comma, referred from jail is directed, comma, is directed against the judgment dated 7/9/2022, passed by the learned session judge, comma, Hojai, in connection with sessions bracket numerical 1 bracket close 02, then again bracket H bracket close of 2021, convicting the appellant under section 302.
Perhaps.
Which section?
We are yet to get our papers.
Also not aware. 302. Section 302 of the IPC, and sentenced to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000 with default stipulation. Full stop. Admit the appeal, call for the LCR, Since Ms. S. Jahan, learned APP Assam has accepted notice on behalf of the state, no formal notice is required to be sent to the state respondent. Full stop. Register to, however, verify if the informant in this case belongs to the family of the victim, and if so, send notice to the informant by registered post with edit, making the same returnable in 6 weeks.
Return of the-
Item 4.
May I please your lordship? Lordship, as per office note dated 18/11/22, my senior A. Ahmed has been appointed as amicus curiae, my lord.
Mhm. All right, so we'll admit the appeal.
Same order will. follow.
Same order. Heard Mr. AML learned amicus curiae appearing for the appellant. Also heard Ms. S. Jahan Swan for the state. This appeal referred from jail is directed against the judgment dated 24/8/2022, passed by the learned sessions judge, Karbi Anglong, Difu, Assam, in connection with sessions case number 3030/2011, convicting the appellant under section 302 of the IPC. Read with 302/201 of the IPC. And sentencing him to undergo rigorous imprisonment for life for committing the offense under section 302 IPC, and to pay fine rupees 10,000 with default stipulation. Full stop. The appellant was also sentenced to 7 years rigorous imprisonment for committing offense under section 202 of the IPC, and to pay fine of rupees 10,000 separately with default stipulation. First up, admit the appeal, call for the LCR, since so and so, rest will be same.
Public.
Item 5.
May I please your lordship? Lordship, I am appearing on behalf of my senior in this matter. Lordship, we have not received the paper book yet.
Appeal has been admitted. Not admitted.
For the first time.
Sure. Then you write, heard Dr. B.N. Gogoi, learned amicus curiae appearing for the appellant. Also heard Ms. B. Bhuya, learned senior counsel, bracket APP Assam, bracket close, assisted by Mr. J. Das, learned counsel appearing for the state. This appeal against conviction has been presented from the jail against the judgment dated 19/7/2022, passed by the learned special judge Udalguri in connection with special bracket NDPS bracket close case number 21/2021, convicting the accused under section 21. This is 20B2C. Under section 20 bracket small b bracket close bracket small Roman 2 bracket close bracket capital C bracket close of the NDPS Act, and sentencing him to undergo rigorous imprisonment for 10 years, and also to pay fine of rupees 1 lakh with default stipulation. Stop. Admit the appeal, call for the records, issue notice returnable in 6 weeks. Since Mr. Das, learned counsel, has accepted notice on behalf of the state, no formal notice is required to be sent in this case. Extra copy of in the case. Let the matter be listed after receipt of LCR.
Item 6.
May I please? I have been appointed as amicus curiae.
Heard Mr. J. Das, learned amicus curiae appearing for the appellant. Also heard Ms. B. Bhuya, etc., assisted by so and so, appearing for the state. This appeal from jail is preferred against the judgment dated 30/9/2022 passed by the learned session judge, Udalguri, Assam, in connection with sessions I case number 19/2020. Convicting the appellant under section 302 of the IPC and sentencing him to undergo rigorous imprisonment for life, and also to pay a fine of rupees 5,000 with default stipulation. First, admit the appeal, call for the record, issue notice returnable in 6 weeks. Since Mr. Das has appeared and accepted notice on behalf of the state, no formal notice is required to be sent to the state of Assam in this case. First, register to, however, verify as to whether the informant in this case belongs to the family of the victim, and if so, notice be sent to the informant by registered post with AD, making the same returnable in 6 weeks.
Obliged.
Item 7.
Lordship and amicus curiae be appointed in this case.
This appeal has been preferred from jail, but none has appeared for the appellant. As such, register to engage a amicus curiae and list the matter thereafter by reflecting his/her name in the cause list. Ms. B. Bhuya, assisted by Ms. B. Bhuya, learned senior counsel, assisted by Mr. J. Das, is present on behalf of the state.
For orders, item 8.
May it please your lordship, according to the last order of this honorable court, we have taken steps for issuing notice upon the respondent number 2, your lordship.
Respondent means informant.
Is the, yes, your lordship, respondent number 2 is the informant.
Informant, yes.
Informant belongs to victim's family.
Yes, your lordship.
What is this matter? Which section?
Yes, POXO.
POXO.
Bill has been granted to there to include the victim.
Your client is out on bail.
Yes.
So then we'll await service report on respondent number 2.
Yes, madam.
Heard Mr.
Yes, they, your lordship.
Is the learned counsel for the appellant also heard Miss so-and-so, learned assisted by so-and-so, appearing for the state. Perused office note dated 5/11/2022. Await service report on respondent number 2. No?
Item 9.
Objection of copy person, no?
May it please your lordship. Initially, I did not make the informant as a respondent here, madam. So, madam, the
Who is the informant?
informant is the mother of the victim, like.
But this is a POXO case.
Now,
So the victim has to be served or the
Yes.
informant?
informant, victim is the minor.
Yes, she is the mother, your lordship, part of the victim family.
So have you taken steps for service?
No, my lord, I did not make party, man. And so I may be allowed to take the respondent as 2, my lord, by hand if possible, my lord. Thank you.
We'll ask the registry to make endorsement. Heard Mr. Anuddin, learned counsel for the appellant, also heard Ms. B. Bhuya, learned senior counsel and additional public prosecutor Assam, assisted by Mr. J. Das, learned counsel, who is present on behalf of the state. First up, Mr. Uddin submits that. No, you're right. Then you're right. This appeal has already been admitted, but the victim or the informant are not included as party to this proceeding. First off, since this is a This is a case of conviction under the POCSO Act, and considering the fact that the victim is a minor girl, we are of the opinion that notice should be sent to the mother of the victim, who is the informant in this case. Full stop. A registry is also directed to implead the informant as respondent number 2. Full stop. Issue notice upon the newly impleaded respondent number 2, implead the mother of the victim as respondent number 2 by making necessary endorsement in the first title. Let notice be issued upon the respondent number 2 by registered post with AD, making the same returnable in 6 weeks. Appellant to take steps
I would like.
for service of notice upon the respondent number 2 within a week from today.
Item 10.
Yes.
Record shows that the paper book is ready and 3 copy of paper book is allowed in the record. But I have not started with copy of the paper book. So registry will be directed to furnish a copy of a paper book to me, and thereafter matter will be fixed for hearing.
I have it. I've got the paper.
All right. Appeal has been admitted
Yes.
and this is ready as regards service.
Yes, he's appearing. He's appearing.
Mr. A. Ahmed, learned amicus curiae is present on behalf of the appellant and submits that copy of the paper book has not been furnished to him. Similar as the you have received paper book?
No, my lord.
Similar as the stand of Mr. B. Decker, learned counsel, your legal aid counsel,
No, my lord.
learned counsel who has entered appearance in this case on behalf of the informant stroke respondent number 2, full stop. Miss Jahan, learned APP Assam, however, submits that she has received the paper book, full stop. This appeal has already been admitted and the same is also ready as regards service. As such, a registry to furnish copy of the paper book to the learned amicus curiae as well as the counsel for the respondent number 2 within 10 days from today. Let the matter be listed for hearing thereafter. Sorry?
He is appointed from the pro bono list.
Not from the pro bono list.
Hmm.
I am willingly doing it.
Okay. Good, good, very good.
Much obliged.
Item 11.
Yeah, please, Your Lordship. My lord, the appeal is already admitted. Readings are also complete. Readings are also complete. On the last occasion, Your Lordship asked them to bring the case diary, my lord. Then appeal against rejection of my prayer for bail, my lord.
We'll fix it.
Today, case diary. Case diary brought the one. Kindly fix for hearing. My lord.
Fix for hearing. When you want it.
In the second week of December. Second week, December, my lord.
Heard Mr. B. Prasad, learned counsel for the appellant. Also heard Mr.
Satyanarayana.
Satyanarayan, learned counsel for the respondent who submits that the case diary has been received and therefore this matter be fixed for hearing. Full stop. On the request of learned counsel for both the sides, the registry is directed to list the matter for hearing in the second week of December 2022. Okay.
Item 12.
ফ্যানখন বন্ধ করে দেবে।
May I please, Your Lordship, as the office number is 1611, Your Lordship, no steps were not taken, Your Lordship. We will take steps today, Your Lordship.
Miss S. Nazneen, learned counsel for the applicant submits that due to oversight, steps were not taken earlier for service of notice upon respondent number 2. The learned counsel, however, seeks 2 days time to take steps. Full stop. Miss B. Bhuya, learned senior counsel, Racket APP Assam, assisted by Miss M. Das.
M. Chakraborty.
M. Chakraborty is present on behalf of the state. On the request of the applicant's counsel, 2 days time is granted for taking steps by registered post with AD for service upon respondent number 2. Let the matter be listed accordingly.
Oblige, Your Lordship.
Item 13 and 14.
So in this case, I take a step, Lordship, that as per office rule dated 22/2/11, Habisible is not there, Lordship.
It's the heavy matter.
Office note dated 2/11.
Yes.
This is what, POXO case?
POXO matter. The other one, there was a bail application, it was heard and rejected.
Hmm.
Sukra Maji, I'll file my objection. And plus, of course, the report will come.
Lakhendra Sureng,
Huh.
that has been rejected.
That has been rejected. This one, I have not taken time on the earlier occasion to file affidavit, I will.
All right, then take it, these orders to be recorded in item 13. Mr. N.J. Gogoi, learned counsel for the applicant is present. Is present. Ms. S. Rahan, learned APP Assam submits that she has not filed, submit that she be granted, how much? 3 weeks time, 2 weeks time
2 weeks.
to file objection opposing the bail claim. Since the APP had not sought time earlier in this matter. Hence, we are inclined to grant 2 weeks time to the learned APP to file objection. In the meantime, register to call for service report on the respondent number 2. Let the matter be listed again after 3 weeks with appropriate note. And in item 14, you write, list this case along with item 13.
Right.
Supplementary list for hearing item 15.
Give the main appeal. Yes.
May I please, Lordship?
Hmm.
My lord, yesterday, my lord, I have done up to page 13, my lord, but naturally I wanted to submit again, my lord. The
Yes.
Azhar, page 46, my lord, held by the PW1, my lord. And the file against the 7 numbers of accused, my lord. Among these 7 numbers of accused, my lord, except 1, 2, 3, others are acquitted from the case, my lord. My lord, PWs, my lord, 13 numbers of PWs has been examined, but none of the defense witness has been examined, my lord. Among these 13 numbers of PWs, my lord, 1 to 5, my lord, PW 1, 2, 3, 4, and 5, my lord, the family members of the deceased, my lord. And PW number 6, 7, and 8, my lord, are the family members of the accused who are already PW 6 and 7, my lord, husband of both the witnesses already acquitted from the case. And PW 9 is the sister, sorry, PW 8 is the sister of the appellant number 1. And independent witnesses, my lord, only PW 9 and 10, my lord. And 11 to 13 are the official witnesses. They are IO, medical doctor, and executive magistrate, my lord, who inquest the report, my lord. Now, my lord, I want to read, I will read from the page 13, my lord. When the sections 498A, 304B, and 34 converted to 302, my lord, then, my lord, another again on oath, the PW1 has been examined. Then from that para, I am going to read, my lord. Page 13, my lord. Cross-examination of PW1 Saiful Islam here on 5/4/2018 on oath. Eliza Khatun is the sister of accused Karimul. At the time of the incident, she was also present in the house. I did not discuss about the incident with Eliza. I saw injury on the person of the deceased, where there were marks of injuries on the body of the deceased. I did not mention in the Azhar. After seeing the dead body, I went to the PS and lodged the Azhar. In the Azhar, it is mentioned that the incident took place in the night of 27th day. About 3-4 months prior to the incident, I went to the residence of the accused. At that time, the deceased was present in the house of the accused Karimul. When I went there, I had a conversation with her. Then she came to our house. When I went there, she asked me to have tea. I denied. When I went, the accused Kamala Khatun was present in the house. Others were absent. Kamala talked to me. Sometimes the deceased used to come in the tears and ask us for money. Their their financial conditions is not good. Deceased maintained a family like marital situation for 3 years. There are houses of other people near the residence of the accused. The residence of the accused can be seen from those houses. When I went, I asked the neighbors about the incident. Prior to this incident, I have not lost any as a heart against the accused. I complied to the village society about the assault on the deceased. According to the advice of the village society, I gave money to the accused, settle the dispute between them. Accused Karimul is a handyman of a vehicle. It is not a fact that the deceased died by falling into the water. Accused person told that she died due to falling into the water. I did not see how the deceased died or who had killed the deceased. PW2 mallet, page 15. Abdul Rahim Bhuya is the father of the deceased mallet. I know the accused person, deceased Hafiza, was my daughter. She was married to accused Karimul Islam. She expired 3 years after her marriage. The incident took place about 2 years back. Around 3 a.m. That night, accused Arman Ali, along with a boy, came and informed me that my granddaughter, that is Hafiza's daughter, was not well. On being informed he informed my wife Onkomala, and I went to Karimul's house to see our granddaughter. On our arrival, we found that our daughter Hafiza was killed and her body was left on the steps to the pond situated in between the houses of Arman Ali and Noimuddin. And our granddaughter was not unwell. Then I went close to Hafiza and saw mark of squeezing on her neck and in the upper portion of her left arm. Blood was oozing out from her ears and nose. A froth and blood were coming out from her mouth. I saw accused Noimuddin and Karimul sitting in their house. Accused Noimuddin, that is my daughter's father-in-law, and my younger brother Saiful lost as a heart, and police from Sorbo police station came and took the dead body away. While nearing Hafiza up to accused Karimul, I gave an amount of rupees 30,000 in cash, gold earrings, a silver chain, and gold bangles as dowry. Accused Karimul and his father Mehmuddin have been torturing my daughter a lot since after her marriage in demand of dowry. I am a Sukidar in a school and I fulfill the demands of.
So the conviction is under 304B.
No, madam, 302, madam.
302.
Sentencing for life, madam.
Under 304B.
Thereafter, 302 was added.
302 was added.
Accused persons by giving them money occasionally. I gave them 25 months of feeding. The depth of the water in the pond on the bank of which Hafiza was lying.
Just a minute, just 1 minute. Why was 302 added here when charge was framed under 304?
Hmm, good.
What is the reason?
Needs to be added. The black people have other death sentence, but otherwise not there. There was a direction. The law was added.
That's right,
Yeah,
but
that
the
can be
point
one reason,
is,
but it's not,
304, the prosecution burden is lesser.
yes.
302, it has to be established beyond
My
reasonable doubt,
lord,
all circumstances.
lordship.
How does it play out in these matters? Because 304B, the circumstances are quite
Yes,
in a very well-defined campus.
Yes.
The marriage,
yes. Within
if the
7
incident
years.
takes place within such and such, there is evidence of torture, etc., and
Yes.
victim
Demand of
dies
dowry.
under circumstances which is not very clear. That's all the prosecution needs to. But the moment it becomes 302, then the 304 circumstances will not help.
Lordship.
Now, since this is a conviction under 302, we'll have to see whether even if the circumstances of 304 are met, even then that conviction may not be sustainable.
My lord, lordship is correct.
So what is the logic behind it? Which judgment says that?
And later on, it was clarified by saying that not mechanically it should be added, but the learned session that should see whether there are ingredients of it. Then it should be added. There are.
Do you have a copy of the judgment, Supreme Court judgment?
Page number.
All right, please proceed.
Mallet. The depth of the water in the pond on the bank of which Hafiza was lying was only 1 foot. And the incident occurred in the month of Ramadan. I found my granddaughter like crying at their courtyard and nobody took care of her. She was then 9 months old. That day I saw Karimul and his father in the house of the accused. His mother fled away. Accused Arman Ali went to inform me. He is the maternal uncle of the accused Karimul. In cross PW1, he is my younger brother. I accused Osman, Nur Hussain, Arman, and Surman are the maternal uncle of the accused Karimul. Appellant number 1. They do not live in the house of the accused. They live in separately houses, but their houses are adjacent to each other. I reached the house of accused Karimul at about 3:30 a.m. on the day of the occurrence. On my arrival at the place of occurrence, I found Karimul and Mahmuddin only. I did not see other persons, and at that time, I was not in a conscious mood as I was crying. On being informed, police came to the place of occurrence at about 10 a.m. by vehicle. And they saw the dead body and questioned me. People gathered at the place of occurrence after police had arrived there. When I came to the house of the accused persons, my son also followed me to the place of occurrence, and again he returned home and found Saiful. Around 10 a.m., my younger brother Saiful came with police. Before I came to the place of occurrence, Saiful told me, "Go, perhaps your daughter or granddaughter may be there." Later, the accused and I went to police. Police questioned Saiful neighbors and me. Around 3 p.m., Saiful lodged the written Azhar with the PS. Police had already started the investigation. Police arrested accused Karimul and his father Mahmuddin. That day itself, accused Elijah is accused Karimul's sister and Mohammuddin's daughter. The matter of giving rupees 34,000 in cash and gold and silver ornaments such as earrings, chain, bangles, etc., was decided at the time of negotiation of the marriage, and the marriage was finalized accordingly. The accused persons said that the marriage would not be solemnized if cash and gold and silver ornaments were not given to them. And owing to that, I gave cash and gold and silver ornaments. I was not forced to give the materials and money at the time of marriage. PW1 cycle knows the matter of giving money and gold and silver ornaments. Several meetings for extrajudicial settlement were held in our village regarding the demand of money made to Hafiza by the accused, and Headmaster Khalilur Rahman remained present in one such meeting. Headmaster Khalilur Rahman knows well about the demand of money made to Hafiza by the accused persons. Kolgase police outpost is situated about 2 miles away from our house. We lodged Ezahar neither with the police outpost nor with the police station with regard to the demand of money made by the accused persons. Saiful was not aware of the meeting for extrajudicial settlement. I did not discuss the matter of holding meeting for extrajudicial settlement in the school. So with the informant, my younger brother Saiful, accused Mohammuddin was present in meeting for extrajudicial settlement. Accused Mohammuddin know about meeting for extrajudicial settlement well. At the time of the meeting for extrajudicial settlement, Muhammad Mastar Nur Alam, Abdul Khalik and a girl named Lavanya Das of the school were present, but daughter Hafiza was in the house of her husband. Karimul was not present, but his eligible was not present. Accused Karimul sometimes went to Guwahati to work there, and he remarried a girl there. The incident took place in winter season. The incident took place in the month of August. The incident took place on 27/8/2009, and Azahar was lost on 28/8/2009. It is not a fact that I did not state that several meetings of extrajudicial settlement were held with regard to the demand of money. It is not a fact that I did not state to police that I gave 25 months of paying to the accused when Hafiza was elite. And that's sometimes I gave money to the accused. It is not a fact that I did not state that at the time of occurrence, the pond had 1 foot deep water. Accused Karimul's neighbors were well aware of the incident about the demanding money from Hafiza by the accused. Nawab Ali, son of Bomi Master and a cow trader, I do not remember his name, know about the demand of money. 15 days prior to the occurrence, accused Karimul came to my house and brother Hafiza from my house. That day, accused Karimul dined in our house. Accused Karimul quarreled with me and my wife. Then Hafiza told us that her husband's house and would come there after some days. After Hafiza's departure from my house that day, I did not make any inquiry about her. I thought Hafiza would live peacefully in her husband's house. It is not a fact that I did not state to police that I saw mark of squeezing injury in deceased Hafiza's neck and shoulder. I do not remember on which date and month and how much money the accused persons had demanded from Hafiza. I offered 25 months of pay to accused Karimul and Hafiza. I gave an amount of rupees 34,000 to accused Karimul for doing business. Accused Karimul did not repay the money to me. I gave accused Karimul rupees 34,000 so that he would be financially sound and my daughter would live happily. I did not witness how Hafiza was killed, but I saw mark of injury caused by hands clearly. It is not a fact that the accused persons neither demanded money from Hafiza nor they killed her. That I have adduced false evidence for the sake of my daughter, and that I have falsely deposed that the pond had 1 foot deep water. L.B. Abdul Rahim. Yeah. Cross-examination of PW2 Abdul Rahim Zia on 5/4/2018 on oath. I know witness Tarabanu. At the time of the incident, Tarabanu was at home. I know witness San Khatun. I also know witness Eliza Khatun. She is the wife of Noimuddin. She is the wife of Noimuddin at the time of the incident. Eliza Khatun was at home. These three witnesses know well about the incident. Deceased was my own daughter. I did not witness how the deceased died and who had killed the deceased. The neighbors know how the deceased was treated and how she lived in the house of her husband. My house is situated about 3 kilometers away from that of the accused persons. The family of the accused was in visiting terms with us until the death of my daughter. Accused Karimul demanded dowry. We treated Karimul affectionately as our son-in-law, but he did not show respect to me as his father-in-law. I went to the house of the accused several times. The members of the family of the accused did not talk to me such. I did not witness who had killed the accused. PW3 days 20. I know the accused person. I knew this is Hafiza. Hafiza was my niece. PW1 is my cousin son of my maternal uncle. Hafiza and accused Karimul were given rupees 34,000 as dowry. Gold earrings, bangles, and silver chain were also given. She was married of 3 years before the incident. After 1 year of her marriage, the accused Hafiza father-in-law Noimuddin and mother-in-law Eliza Khatun tortured and assaulted her in demand of dowry. And mother-in-law is the Kamila Khatun, but Eliza is the daughter whose age was 9 years something like that. Because 2-3 weeks of her death, Hafiza came to our house and said that she was assaulted for dowry and would not go back. Hafiza told us that Karimul remarried in Guwahati. While accused Karimul was in Guwahati, his father came to bring her back. When he was asked whether Karimul had remarried in Guwahati, accused Noimuddin said that Karimul's second wife would not come here, and we convinced Hafiza to go back and send her with Noimuddin. About 2 weeks of her departure, accused Arman came to the house of PW2 and informed that Hafiza's daughter was unwell. Then PW2 and his wife went to the house of the accused. It was the time of taking Sehri, a meal taken before keeping fast in the month of Ramadan. I did not go. In the meantime, the villagers informed the family of PW2 that Hafiza had died. Getting the information, I immediately went to the place of occurrence and saw Hafiza lying dead on the steps on the bank of the pond of the accused person, and her mother-in-law sitting beside her. When police arrived, Hafiza's mother-in-law, Kamila Khatun, disappeared. I observed the dead body of the Hafiza and saw black squeezing mark on her neck and on the upper portion of her right arm. Thought was coming out through her nose, and blood was oozing from her mouth. Police came to the place of occurrence and held an inquest on the dead body in my presence, and I put my signature. The dead body was taken away for postmortem examination. Because accused Naimuddin brought his daughter-in-law Hafiza to his house before 15 days of the incident. He came alone, but accused Karimul was at his house itself, PW2, and I have separate houses. When accused Naimuddin came to bring back Hafiza, I too was present at the house of PW2. Khan. Abdul Halim and his 4-5 brothers were also present at the house of the PW2 when accused Naimuddin came to bring Hafiza back. The incident took place in monsoon season. I do not remember on which date and in which month and how much money was demanded by the accused person, and no case was lost with Kolkata in this regard. There was no cordial relation between the two families due to the demand of dowry made to Hafiza by the accused person. I came to know about the matter of dowry from the deceased. It is not a fact that I did not state to police that the girl came home before 2 weeks of the incident. That she said that she was assaulted for dowry and she would go to her husband's house again, and that accused Karimul remarried. It is not a fact that I did not state to police that accused Naimuddin came to bring Hafiza back. That Naimuddin said that Karimul remarried, and that when he said that he would not allow Karimul's second wife to come to his house. We sent Hafiza with her father-in-law. PW2 Abdul Rahim Bhia knew well about accused Naimuddin bringing his daughter-in-law Hafiza from the house of the PW2 for the last time. It is not a fact that I did not state that on my arrival at the place of occurrence, I saw accused Kamila sitting beside the dead body of Hafiza. First, a person informed the family of the PW2 that Hafiza's baby was unwell. I got the information in the early morning on 24/4/2009 that Hafiza had died in the house of her husband. It is not a fact that I have adduced false evidence. PW4, page 23. I know the accused persons, Halim here. I know the accused person. This is Hafiza, was my granddaughter. She was married to accused Karimul 3 years before her death. An amount of rupees 34,000 and ornaments were given to Hafiza as dowry. Hafiza came to her mother's house time after her marriage. I heard that Karimul remarried and would not continue the conjugal life with Hafiza. In the morning on the day of the occurrence, we were informed that Hafiza's baby had died. But going there, we saw that it was Hafiza who died. I saw injury on Hafiza's body. Blood was oozing from her ears and nose. I saw injury in the upper portion of her left arm and neck. Police came to the place of occurrence and questioned me. Hafiza was brought from her father's house 2 3 days before the incident. I do not know who had brought Hafiza from her father's house before her death. There were differences in the family of Hafiza's father-in-laws, and meeting was held several times for sorting out the differences, but I do not know the reasons for the differences never went to such meeting. It is not a fact that I did not see marks of injury on Hafiza's neck and hands. An amount of rupees 34,000 in cash and ornaments were given in Hafiza's marriage with the agreement of both the parties. I did not state to police that blood was oozing out from Hafiza's nose and mouth. That I saw injury in Hafiza's neck and hands, and that an amount of rupees 34,000 was given at the time of her marriage. Usually 5 minutes. Musammat Onkomala, the mother of the deceased. I know accused are removed and the other accused person. The informant is my brother-in-law, younger brother of husband, about 2 years and 3 months, 2 years and 3 months ago. My daughter Hafiza passed away prior to 3 years of the incident. I gave my daughter Hafiza in marriage to Karimul. At the time of marriage, accused Karimul demanded 34,000 rupees in cash, gold earrings, silver chain, gold bangle, and accordingly we give these articles with Hafiza at her marriage. Even after the marriage, Hafiza and Karimul were on good visiting terms to our house for 2 3 months. Since then, accused Karimul harassed my daughter for money and sent her to bring the money. Then I again gave her some amount of money and sent her back. In the meantime, accused Karimul went to Guwahati and he got married for the second time and came back home with her. This time, Hafiza came to my house and said that since Karimul got married for the second time and brought his second wife home, she would not go there again. That time, Hafiza stayed in my house for 9 months. During that time, Karimul came to my house and stayed in our house that day. On the following day, 2 younger sisters of accused Karimul came to our house, and I sent Hafiza to their house. But after two weeks, one day at the time of Ramzan fasting, at the time of taking Sehuri, 2 persons came to our house and informed that Hafiza's daughter was ill. Then my husband, that is informant number 1, and I went to Hafiza's house. And going there, we saw that Hafiza was killed and her dead body was kept lying on the bank of the pond. I came near to Hafiza and saw a scratch mark on her neck, and blood was oozing from her nose and mouth. I saw mark of injury in both of her upper parts of the arm. I raised the head of Hafiza and I found a hair missing in the rear side. The accused persons harassed her, demanding money and killed her. Police came to the place of occurrence. After seeing the dead body, I went to Hafiza's room and going there, I saw the bed and other articles of her room lying in a disorganized manner. That is it. Accused Karimul was engaged in vehicle business. prior
One
to
minute,
the-
1 minute. Mr. Mahajan, you are waiting for which case?
Part two this one,
Which item?
99.
99. File they have to bring, I think. Oh,
This will go on, this bench is not available tomorrow and day after.
those judgments I've got, your lordship wants to say.
Yes.
Then I want-
Acha, the learned judge has held that 498A and 304B could not be proved in this case.
Yes, yes.
Huh? But 302 IPC has been held to have been established.
Yes.
And that too on the ground that only the accused persons were at home. Nobody else.
There's no explanation from
There is
this.
no explanation. That is the only ground. No explanation is just an additional link in the chain.
The presence was proved.
Hmm?
Presence, they were there.
Hmm.
They would ought to have filed, lodge a complaint or lodge an FIR, your lordship. And in fact, wrong information was given to the parents of the family, in a victim's family, that the daughter is not well. And lordship, that drowning and all.
But what happens? Supposing we hold that the session judge was not correct in coming to the conclusion. Supposing we hold that 304, there is evidence.
Lots of ingredients of
Lots of
304B.
Then what happens? What is the law on that? What is the law on that?
In this case, my lord, only on presumption, at the time of expiry of the, this is Hafiza, my lord, the only parents of the appellant number 1 is present. Madam.
Only on presumption.
Yes.
But
I,
304B is also on presumption only.
my lord. But before death, my lord,
The
there was.
learned judges held that this 34,000 was given as Sridhan. But that's not the point. Point is whether there was demand for dowry
Yes.
and there was torture. It appears there are evidence and the death happened within 7 years.
Yes.
It was
Yes.
third year of
Yes,
marriage.
third year of marriage.
And it was under circumstances, unnatural death.
Yes,
So what happens, supposing
yes.
we may agree with him and set aside the order.
Yes.
But
So
if
your
we
lordship
find that,
reverse the conviction?
no,
Yes.
please,
My lord.
supposing we hold that 302 charge was not proved, but there was enough evidence to establish the charge under 304B. Can we do that in the appellate stage?
Yes, your lordship.
What is your stand, Mr. Islam?
My lord, I beg to pray before the worship court, my lord. At the time of occurrence, my lord, the appellant number.
No,
one-
you please answer the question.
Yes, my
Don't go into the merit.
lord, my
We have not decided or rejected your appeal,
lord.
but we may.
My lord.
What we are indicating is that instead of this ground, if we hold the appellants guilty on the other ground, what would be the consequence? Can you enlighten us? What is the law
My lord,
on this?
provision 304B, my lord, in view of this, my lord, demanding of dowry. That is reflected, but my lord, before the date of occurrence, my lord, at the time of marriage, that gold ring, earring, etc. 34,000.
You have to answer that question. In 10 minutes, we'll ask you. You have to give us a legal answer. But let me just have a conference with my brother, learned brother. Nine. How is it with 12? Then later, we have one. What we are asking is, perhaps you have also seen, and I don't know what the appellant's counsel will say. We have enough evidence to convict under 304B. There is no explanation. There it is a very relevant factor. So why should we go into 302 here? That appears to be on some presumption.
Yes,
There, the main ground is no explanation.
yes.
But we can always convert it into 304B. There is no escape that the evidence that there was a demand for dowry, there were torture, injuries were seen. These things have remained unimpeached. So why should the court discard it? And this is not a death sentence case.
No.
So the under 304B also life imprisonment can be given,
Yes.
right? So why, viewed from any angle, this can't be a case of acquittal.
Yes.
But you are to answer the court's query on this.
Madam. Regarding the Malot, which 34,000.
34,000, you forget it.
No.
That was given voluntarily by the father.
At the time of this.
That has nothing to do with this case. Apart from that, some jewelry has been given.
Yes.
So that was given during the marriage.
Yes.
After that, there was demand for money.
Right.
That there is evidence to show that the daughter, there are two twin murders here.
No.
The granddaughter has
That,
been-
no, she's alive.
She's alive.
Wrong information was given to the parents, my lord, of the victim.
Okay.
The daughter is not well.
Hmm.
Granddaughter is not well.
So in the murder charge, what are the circumstances? First, she was found lying near the pond. And so people say that it's 1 foot deep.
Yes,
How can someone drown in 1 foot deep
Yes.
pond?
yes.
But is the death due to drowning?
No, the doctor's opinion. It's
Doctor
different.
opinion, Madam.
It's there, your lordship.
What is the doctor's opinion?
Yeah.
Kindly, page 40.
Page?
40, your lordship.
No, we'll come back again, but
My lord.
Madam.
just to get an overview of what is the matter.
Is 40 of the paper book.
Hmm.
In my opinion, the death is due to shock and hemorrhage, the result of head injury. And thereafter, I did not mention about the age of the injury 15 minutes. If a person jump in a pond, she may sustain only one injury, but not on the both sides. I conducted a postmortem on body of deceased in reference to so and so. Lacerated injuries were found, your lordship. And she knew swimming, my lord.
She knew how to swim.
Yes, how to swim.
Hmm.
It came on record.
Prima facie, the
The
judgment does not appear to be happily worded. But at the same time, There is sufficient evidence. This can't be a case of acquittal. I have glanced through the materials here. The judgment also I have seen. Who is PW9?
PW9.
is the owner of the
Vehicle owner.
vehicle of appellant number
PW 9 and 10.
PW9.
Used to work.
So there is evidence that he says that he went back, you went and spent the night in the house.
But a precise date was not given, that on that day only he was lordship.
All right, all right.
PW 9 and 10 are the independent witness. They are about 10 to 12, 20, 12 miles away from the house of the appellant number 1. At that time, when he was there under PW9, his car was driving. And the roommate was the brother of the PW9. He is the roommate. Along with one Nurul Islam, a roommate, he was there and the right. And but the month was the Ramadan month, that is why, up to 11, 10, Tarawih namaz was performed, and thereafter, but that was not recorded here. And thereafter, Sehri 1 p.m. he should be get up, and Sehri has been taken before 3. And that is why, and at that time of Ramadan month, each and every Muslim people perform namaz as Tarawih, Tahajjud, etc. That is why up and down is going on. That was I myself also done it. That is why, he is there, about 10-12 kilometers distance from the house.
Yourself with this, he is a criminal. A criminal may not adhere to all these things. These are normally what is done.
And also, my lord, in the appellant number 1's house, only 9 years sister and.
So how did the victim die? How did she die?
My lord, in view of the paper book, my lord, what I've studied in this paper book, my lord, in the month of Ramadan, my lord, at 3 p.m., 3 a.m., she got up and bring the message from the neighbor. That is Arman's house. He who acquitted from the case. And in between these two houses, my lord, there is pond, my lord. And on the, as per doctor report, he slipped in and dressing in the head in the
Not
backside
possible.
and lacerated.
Both sides injury not possible in
But
pond.
doctor, one lacerated with short, my lord.
No, the doctor says there can't be injury on both the sides. See his cross-examination.
Back of the head, no?
If a person jumps in a pond, she may sustain only one injury, but not on both the sides. How many injuries? Both sides there was injury.
One receiving injury over the back of the head. Size so and so, bleeding from right and left ear, black color bleeding from nose, swelling over the front side of the chest and so, black bluish in color, soft tissue swelling on both sides of the so and so, all the injury anti-mortem.
May I read again, my lord, for page 40, my lord?
The postmortem report.
How can there be soft tissue swelling in if a person jumps into the
Yes.
pond?
Yes.
All right, you argue?
No. Dr. Subhanin's statement is here, page 47, the weapon of which the injury was caused is not mentioned in the PM report. This type of head injury may be caused by dashing on stone if the depth of water is low. In some cases, due to head injury, bleeding may occur through nose and ear, but not in all cases. In the PM report, my lord, it is not mentioned whether the injury number 4 is grievous or simple. The age and time of the injury are not mentioned. The name of neither the father nor the husband of the deceased is mentioned in the PM report. Generally, the name of the husband or father name is mentioned in the report. I cannot say the exact time of the death by going to the PM report. I may read through the page 26, my lord, in close of the PW 5 minutes. Onkomala, mother of the deceased, my lord. Accused Karimul was engaged in vehicle business prior to the marriage. Therefore, prior to the marriage, he said that since he has to pay installment for his vehicle. If we give him 34,000 rupees in cash, he will marry our daughter. Then we agreed with accused Karimul and gave our daughter Hafiza in marriage to the accused person. Since after the marriage, although accused Karimul visited our house and dined at our house, he remained upset, although accused Karimul came to talk Hafiza for the last time. But he went to Korgasia and two of his younger sisters to Hafiza to her husband's house. Although my husband was in his working place on the day Hafiza was taken away, he knew about it. That day around them, my husband came and after returning home, when he asked me about Hafiza, I said that she was taken away by her sister-in-law, younger sister of husband. Prior to the incident, I saw the second wife of Hafiza's husband. It is not a fact that I did not state before the police that Hafiza was sent to our house on demand of money. It is not a fact that I did not state before the police that I heard that accused Karimul had got married to another woman, and I got the information that my granddaughter had died. It is not a fact that I stated before the police that I got the information that Hafiza had died in the early morning. It is not a fact that I did not state before the police and police that I found injury mark in both of the Hafiza's arms. Spaces mark on the neck, blood and oozing from her nose and mouth, and there and hair was missing in the rear side of her head. I did not witness as to how Hafiza was killed. It is not a fact that I did not state before the police that I had found bed, table, chair, etc. in disorganized manner in the room of Hafiza. I saw injuries on the body of the deceased. I accused Naimuddin did not visit on the day when Hafiza was taken to her husband's house. It is not a fact that I had adduced false evidence and Hafiza did not tell that the money was demanded as dowry. Prosecution of the PW 5 Kamala on 5/2018 onward. The deceased was my daughter Karimul, and the deceased got married on the acceptance of both the families. We arranged the marriage because Karimul and his family members were good. After the marriage, I went to the house of the accused for 2-3 times. Previously, we did not lodge any case against the family of the accused. Occasionally, the deceased and my son-in-law came to our house. I treated them very well, but occasionally Karimul created troubles. He even assaulted the deceased when he was in our house. I did not want to break their marriage. The deceased stayed in my house along with her sister-in-law. Since Karimul was engaged in vehicle business, so he did not stay much in our house. I suspect that the accused killed my daughter. I did not witness it. PW 5 suspected. PW 6, my lord. This is the Tara Banu, wife of accused number four, Usman Goni.
Yes,
Tara Banu.
yes.
I know the accused persons. I also know the informant accused Usman is my husband. About 2-3 years ago, accused Karimul's wife Hafiza Begum died. I do not know as to how Hafiza Begum died. There is road in between the house of the accused Karimul and mine. About 12 a.m. on the day of the incident, accused Karimul's mother and his father went to call us and they searched for Karimul's wife Hafiza. Hafiza was not in our house. Then I came to know that Hafiza was not in the house, and later I saw the dead body of Hafiza lying in the pond of neighbor. On that night itself, I did not see any mark of injury on Hafiza's body. Many people searched for Hafiza. Since the incident occurred during monsoon, the pond was filled with water. Later, when the dead body was found, it was lifted from the water. Hafiza and Karimul got married before 2 years of the incident. I knew that they led a happy married life. Although Karimul got married to another woman, I knew that she was not taken home. Later, police took the dead body for holding postmortem examination because of the PW5. Accused Osman is my husband. Accused Nur Hussain, Arman, Surman, all live separately. They do not stay with the family of Karimul. They are all nephews in relation. The pond on which the dead body of Hafiza was recovered was adjacent to the house of Karimul. There are ponds in both sides of the road, and there is an approach road to the house of Karimul along with side of the pond. At that time, since it was monsoon season, the pond was about 15-20 cubic. Occasionally, we went to the house of Karimul and met Hafiza also. This is Hafiza knew me well. I had a conversation with her. This is Hafiza. This is Hafiza never told anything before me against her husband, father-in-law and mother-in-law. Hafiza lived happily with her husband, father-in-law and mother-in-law, and they also cared about her. Accused Karimul is a driver. And since accused Karimul drives vehicle, he stays outside for 15 days in a month, and thereafter he came home. On the day of the incident, accused Karimul was not in house. Since 1 week before the incident, accused Karimul was not in house, and around 8 a.m. on the following day of the incident, he was informed about the incident, and then he came to the house. There are chances of drowning if a person does not know swimming. Hafiza did not know swimming. There are ponds situated in both sides of the road, which leads to the house of Karimul, and there is no fencing in the side, and it is the only road that led to the house of accused Karimul. When we found the dead body of the Hafiza in the pond, we lifted the dead body on the road by holding together and tried to expel the water from her body, assuming that she was alive. But water was releasing from nose,
Family
ear.
member accused. Okay, witness Martins. The accused family members have been examined as PWs.
My lord. 6, 7, and 8, my lord. These are the 6 is the.
All right, they are,
My
the
lord.
prosecution doesn't know how to
My lord,
conduct a
my lord,
case. We have come across these matters repeatedly, day in and day out. The PPs don't have an idea what to do. They are examining the family members of the accused persons. Obviously, these people have come and said they had seen nothing, no injury, nothing. These are all hostile witnesses. But in the first place, we fail to understand how these people were called as witness on the prosecution side.
Yes, sir.
Will they implicate the accused or protect them
Yes, sir.
or screen them?
Okay.
Absolutely pathetic condition. Yes,
Hello.
you know.
When we found the dead body of the officer in the pond, we lifted the dead body on the road by holding together and tried to expel the water from her body, assuming that she was alive. But water was releasing from nose, ear, and even from the mouth of the officer. At the time of commotion arose among the people, and they thought among themselves that accused Karimul's wife Hafiza died by drawing in the pond. After expelling the water from Hafiza,
He has also said similar thing.
Yes, ma'am.
Officer didn't know how to swim. Pond was full of water, chances of drowning if person doesn't know how to swim. It's more or less the repetition of the evidence of PW6.
Madam.
Probably 8 has also said the same thing.
Seven is the wife of Malad.
It is the sister
Arma.
with whom the victim was sleeping on the very.
Eight is the-
She said that she deposed that.
All right.
Married by 7 Malad.
8 was declared hostile,
Yes.
so did not support prosecution case. The 6, 7, 8 was completely unnecessarily examined.
Gosh.
PW7 Malad. Accused Arman Ali is my husband. Arman was the accused in this case. Malad, he is acquitted. The rest of the deceased persons are our family members. Accused Karimul is the son of my sister-in-law, the husband's younger sister. Deceased Hafiza is my niece-in-law. About 3 years before the incident, deceased Hafiza and Karimul got married. Accused Karimul got married to another woman when Hafiza was ill. No quarrel took place between accused Karimul and Hafiza regarding the second marriage of Karimul. On the day of occurrence, Karimul was not in the house. Accused Karimul was a driver and he stayed outside for about 15 days in the month. At that time, accused Karimul used to stay in the.
So what is there? What is there in this? PW 6, 7, 8, there is nothing.
Nothing. They are the family members of the accused man.
Let us keep it. They are the relatives of the accused persons. All right.
Eight is the sister of the accused number 1. Karimul. Then
So, Mr. Islam, first of all, what is your submission?
my submission, my lord, there is no proof of, I have done some points, my lord. My lord, in this case, my lord, there is no any eyewitness. All are hearsay witness. On presumption, my lord. My lord, why I was not, why the accused are not informed to the police, nor to her.
So let us see which is the relevant part of the findings of the trial judge.
No.
So it appears the learned public prosecutor, whoever was conducting this case, we don't know who he is or she is, but a brilliant person, thought that the more witnesses you examine, the better it is. So he has examined the prosecution witnesses as well as the defense witnesses, all as prosecution witnesses. Fantastic. Yes, please. Which is the relevant parts?
My lord, the decision and reasons thereof since page 79 in the judgment. My lord.
Page 79.
Of the paper.
Yes.
Lordship, page, para 34 would be relevant, page 88. 34.
We can start from page, Mr. Aslam, from page para 34.
Para 34, page 88, ma'am.
Let us read from here.
As can be seen from the testimonials of the prosecution witness, discussed about PW1 Saiful Islam Bhuya, PW2 Abdul Rahim Bhuya, PW3 Mubarak Ali, and PW5 Muhammad Ankomala have deposed that when they reached the house of the accused, they saw that the Hafiza was killed and her dead body was lying on the bank of the pond with marks of injuries on the dead body. PW11 Dr. G.C. Medhi has deposed that the death was due to shock and hemorrhage as a result of the head injury, as there is no evidence about how Hafiza sustained the injuries, and the accused Karimul Islam and his parents, namely the accused Naimuddin and Kamala Khatun, did not inform the police about the death of Hafiza in their house. The same proves beyond all reasonable doubt that it were the accused Karimul Islam and his parents who had caused the injuries to Hafiza that caused her death. Now kindly see page 96, para 51.
Para 51.
51. In view of the above, the intimation circumstances which the prosecution has proved that the accused Karimul Islam and his parents, namely the accused Naimuddin and Kamala Khatun, that at the time of causing the injuries and death of Hafiza Khatun, except them, nobody else was present in their house, proves beyond all reasonable doubt that they had caused the injuries and death of Hafiza Khatun. As the death of Hafiza Khatun was caused due to the injuries sustained by her, but the accused Karimul Islam and his parents did not take her to the hospital nor treatment after the sustained the injuries, and also did not inform the police after she died. The action of the accused Karimul Islam and his parents, namely the accused Naimuddin and Kamala Khatun, falls within the definition of murder. In para 50, my lord. But though the PW 1, 2, 3, and 4, and 5 have deposed that at the time of marriage they gave rupees 34,000 and gold and silver ornaments as dowry, and the defense also did not deny the same, and in the cross-examination, the PW4, the grandfather of the deceased Hafiza Khatun, has stated that they gave the same as per the agreement of both the parties. The same cannot be held to be dowry and seems to be the stilhon given to the deceased Hafiza Khatun at the time of marriage. Further, though the witnesses have also deposed that demanding dowry, the accused subjected the deceased Hafiza Khatun to torture, and she went to her parental home and told them about the same, and village meeting was held to decide the matter. As the prosecution did not examine then any person who had attended the village meeting, it cannot be held that the accused subjected the deceased Hafiza Khatun to torture demanding dowry. Para 52. It seems as the deceased Hafiza Khatun objected to the accused Karimul Islam contracted second marriage, and she left the matrimonial home and took shelter in her parental home, and from her parental home, the accused had taken her back to their home, and as the alleged incident occurred after a few days of the said incident, the accused seems to have committed the murder of Hafiza Khatun for the same. Therefore, though the prosecution has failed to prove beyond all reasonable doubt that the accused had committed the offences under section 498A 304B IPC. The prosecution has been able to prove beyond all reasonable doubt the accused Karimul Islam and his parents, namely the accused Mahmuddin and Kamala Khatun, had committed murder of Hafiza Khatun by intentionally causing her death, which is an offence punishable under section 302.
We find this observation in page 97, second part of the paragraph, unsustainable in law. Though witnesses have deposed that demanding dowry, the accused subjected the deceased Hafiza Khatun to torture, and she went to her parental house and told them about the same. The village meeting was held to decide the matter. As the prosecution did not examine any person who had attended the village meeting, it cannot be held that accused subjected the deceased Hafiza Khatun to torture. This reasoning, we are finding it very difficult to accept. Who has been examined or who has not, that's not the point. Point is whether there is evidence to prove that there was demand for dowry and there was torture. If there is evidence, this is a clear open and shut case under 304B.
Actually, ma'am, madam, entire matter occurred after the second marriage of the accused appellant, madam. Now, what happens, my lord? Actually, the deceased Hafiza cannot bear the second marriage.
So she killed herself.
Perhaps that is the compel.
So what happened? She killed herself.
No, that is why, my lord, no, my lord, how she killed, that is regarding that I have nothing to say, my lord, because, my lord.
That is the only thing we are going to look here, nothing else. Who married whom, who liked, who disliked, these are not our business. The only thing we'll see is how did she die?
Right.
The accused persons, whether they are responsible for the death, and if so, under which provision of law. So right since the beginning, we are saying that 302, there could be some doubts whether the chain is complete or not. But there is no doubt that 304B charge is made out. What have we got to say? We are asking you on the legal point. What is your answer? If you have nothing to say, we'll hear her for 10 minutes and close the judgment.
My lord, in persons of independent witness, PW 9 and 10, my lord. My lord, the appellant was not at home. He was one handyman.
That is not required. That is not required. Section 304B of IPC. You have the IPC.
Yeah, my lord, my lord.
Read it, please. What does it say? Purely ordered judgment as most of them. Who is the judge?
May please. 304B dowry death.
Yes.
304B dowry death, madam. Where the death of a woman is caused by any burn or bodily injury or occurs otherwise, then under normal circumstances within 7 years of her marriage, and it is shown that soon before her death, he was subjected to cruelty or harassment by her husband or any relative of her husband, or in connection with any demand for dowry, first death shall be called dowry death.
So what is to be shown? That the death happened other than in a natural course. Number two, that it happened within 7 days, 7 years of marriage.
Within 7 years.
And that there is evidence of cruelty and dowry demand. These are the only three things. Where the accused was at that night, whose house he stayed, these are not relevant. So the death happened within the 3rd year.
Within a period of 7
Correct.
years.
It was an unnatural death. Nobody knows how she died. Let's take it that way. And the third is, there is evidence of the PWs which says there was demand for dowry and she was tortured. That evidences remain unimpeached. So whether somebody else should have been examined or not, or was not examined, how does it matter? If these three ingredients are established, then at least a clear case is made out under 304B. If that is so, why should we, even if 302 chain of circumstances is not complete, we can always convert the conviction into 304B. What is your response to that? We are asking you. This is the third time. What is your response to this on legal point?
Judgment delivered on on 11/2/2021, since then already
What is he saying?
1 year 9 months already.
What are you saying? Huh?
Appellant number 1 have the minor children mallet.
That is another matter. We are asking you on the law point. You are going into minor children. What is your answer on the law point?
Then I will find some citation mallet and place before the lordship court as in view of the citation mallet. And
You will find citation.
mallet.
When?
In the next week, mallet.
No, but have you understood our query? If you don't understand, then we'll have to engage an amicus query, because you see, this is a query which is purely a legal issue. The learned trial court has held that she died in the matrimonial home. It was a homicidal death. The accused persons could not explain how the death happened. But the wordings are that when she suffered injuries, how did it happen? That is the expression used. So therefore, it is proved beyond reasonable doubt that they have killed the victim. That part of that piece of observation technically may not be very sound, may not be sound. But let us even assume, for the sake of argument, that the chain of circumstances to prove the charge under section 302 has not been established. Number two, this is not a case of one accused being punished. So if there are multiple accused, section 34 has to be roped in. There is not even a whisper about section 34. So 302 conviction cannot be sustained. There is no doubt about it. Because more than how many appellants are there?
Here 3. Originally there were, lordship, 6.
7.
3 can be acquitted.
Originally
Yeah.
7. 4
Yes.
also acquitted.
4 have been
okay?
acquitted.
Yes, 3 convicted.
So how can 3 be convicted under 302 without adding 34? There is no finding about any intent. So to that extent, this judgment is not sustainable. But at the same time, we find that this is a case which squarely fits into the conditions of section 304B of the IPC.
Yes.
And even charge was framed in that, again, under that provision.
Under section 30.
If there is evidence to show that the charge was proved, but the trial court has erroneously held that it was not proved, what is the harm in this court, the appellate court, converting the conviction from 302 to 304B? We always do it in murder case, 304 part 2, part 1, we do it.
Sometimes
We are asking you the question, we are asking you to address the court. First of all, have you understood our query? If you have understood, you want time, no problem, we can fix it in the next week. But that is the long and short of the matter. And all these evidences, all these witnesses from 6 to 8 are completely meaningless.
Yes.
9 and 10, all right, independent witnesses. But their testimony lives more uncovered than what is covered. They could not say which day, when did he stay, whatever. So this is neither here nor there. Practically, he has taken a plea of alibi, which now this is the disaster that has happened. You see, the prosecution has examined witnesses without understanding, randomly has examined witnesses. This is what is happening in most of the cases. The prosecutor doesn't know how to conduct a trial. They don't know. What are the legal principles, which witnesses to be examined, which 90% of the prosecutors, our experience has been, has not, we're talking about the trial court,
Yes.
has no idea how to do it. These are all appointments made through what process you know, and then they do whatever they feel like. And the real questions crop up when the matters are listed in the appeal before the High Court. But by then it is too late. All right, we'll grant it. But we can always do something which is legally permissible. We propose to convert the conviction of the appellants from 302 IPC to 304B IPC. What is your response to that? How much time you want? You tell us a date, we'll fix the matter on that date.
Monday koribo, Tuesday koribo. Tuesday.
When?
Tuesday, coming Tuesday.
Coming Tuesday. This will remain parted before
Yes.
this. You also examine the matter
Yes,
and
yes.
address the court on
Yes.
that. This is a matter of 15 more minutes.
Yes.
Another 15 minutes and then we'll close it. Rest of the things are undisputed. PWs 1 to 5 have brought in enough evidence. These have remained unimpeached. These have remained unimpeached. PWs 6 to 8 are all on. They were trying to impress upon the court by deposing that this could be a case of drowning by accidental fall in the pond. So this is neither here nor there. And secondly, this is not supported by the evidence of PW 11. The doctor, he clearly says there can't be injuries on both sides on falling down in the water, which is logical. If somebody falls down in water, there can't be injury on both the sides.
And the neck also.
And then neck, there are soft tissues rupture.
Yes.
How can this happen in the water? So therefore, the postmortem report clearly establishes homicidal death. 34, without 34, this conviction is not sustainable. But the answer lies in 304B. Heard Mr. S. Islam, Learned Counsel appearing for the appellant G. Islam. B. Islam.
B Islam.
Also heard Ms. B. Learned Senior Counsel, bracket APP Assam, bracket assisted by Mr. J. Das, Learned Counsel, appearing for the state. After hearing the arguments of the appellant's counsel at some length, we are of the prima facie opinion that even if the conviction of the appellants under section 302 of the IPC, without the assistance of, without applying section 34 of the IPC, is held to be unsustainable. Yet there are sufficient evidence on record to conclude, sufficient evidence on record for this court to convict the appellants under section 304-B of the IPC. Full stop. This is more so since the learned trial court had also framed charge against the appellants, accused persons, under section 304B. Full stop. 304B, but eventually had acquitted the appellants in respect of the said charge while convicting them under section 302 IPC. Full stop. Since this issue, since this question raises a legal issue which the appellant's counsel seeks some time to examine, hence, on his request, we defer the hearing of this appeal till 29/11/2022. Let this appeal be listed again on 29/11/2022 as a fixed part-heard matter. Please check that judgment which says 302 has to be added mandatorily. What is the logic behind it? Please tell
No, it
us.
should not be like mechanically exercised.
No, mechanically is fine, but
Yes.
in a case where 304 ingredients are there, 302 ingredients may not be there.
Yes.
No, in fact, first decision, Supreme Court said every trial court should add because death sentence otherwise is not there in 304B. Thereafter, Jaswinder Singh's case came. There it is said mechanically it should not be added. If ingredients are there, then 302 should be added.
But that
And
goes
you-
without saying. If there
Huh.
are ingredients, then it should be added.
And during the trial, they have said,
Mm.
if 302 materials are found, then conviction should be given under that. And if it is not found, then 304 they will go.
That is what we are finding in this case.
304B will be an alternative charge. This is what Supreme Court said. And of course, conviction both under 304B and 302 cannot be there.
No, that is
This is,
unwarranted.
this is different.
So that's what we are saying.
Hmm.
302 difficult.
Hmm.
The primary reason is that 34 is not there. There is no common intention. There is no individual role ascribed. How can there be conviction of 302?
Everyone has.
Cannot. So
Jaswinder
on
said
that ground it goes. He didn't argue that point, but this is the
Yes.
first point.
My love.
If you were in his place, this is probably the first point you would have argued
Yes.
that. But luckily, 304B is staring in the face
Yes,
for the
yes,
prosecution,
yes,
and unluckily for him.
yes.
Let's see whose luck runs out on 22nd,
29th.
on 29th list on me.
Only
Yes, is
judgments
there,
are there, Lordship.
yes, you put it in the record. Is there any other matter? This bench is not sitting tomorrow and day after. So anybody has an urgent short matter hearing? Otherwise, we can commence hearing again on Monday or
28th.
maybe 28th. Tomorrow and day after, this bench is not available.